Welcome everyone, and thank you for joining us for today's webinar. In this unprecedented time, we hope that you are all safe and healthy, and we appreciate you taking the time to be here today. A little housekeeping before we get started. We will be running a live Q&A at the end of the webinar. So if you have any questions during the presentation, please type them into the chat box in your Zoom control panel. And if you miss anything, don't worry. We'll be sending you a link to the recording when it's available. We will also be presenting poll questions that you'll be able to answer from the device you're using to view this webinar. My name is Amy Chamberlain, and I'm an instructional designer at the CE Shop, the leading provider of online real estate education. Today, we are reviewing contracts and contract law as they relate to the national portion of your real estate licensing exam, presented by Kathy Connolly. A significant portion of your licensing exam will be on contracts. While your pre-licensing course thoroughly covers this topic, our goal is to provide you with additional learning experiences that enhance your knowledge and preparation for your licensing exam. Our presenter today is very well known in the Maryland real estate industry. Kathy Connolly comes to us with over 30 years of experience. And as the former executive director of the Maryland Real Estate Commission, she is absolutely one of the best resources available to you as a student. Now, without further ado, we will turn the time over to Kathy.
Thank you, Amy. At this point, I'm going to turn off my video and just concentrate on the slides with you all, but just wanted to say hello and welcome. And we will have a Q&A. We're going to do the poll first to see where you are as far as your course goes and where you are in the course. Then we're going to do the contracts overview. We'll have a Q&A at the end, and we'll give you some additional resources about your exam and when you're going to take it and what you'll need to know. And we will finish up within the hour. So figure on being with us for about an hour. And you can type in your questions, and Amy will be fielding them at the end of this presentation. So I'll chat with you all later. If I can turn off my video. There we go. Okay. All right. So let's get started. So our first poll today is going to be about how far along you are in your course. So if you could answer that poll for us, it would be very helpful. Okay. So it looks like at this point we have about 22 that are almost done. We have a few that have just got started, and a bunch of you right in the middle that are somewhere between 25 and 75%. No matter where you are in this section of the course, you will need to know about contracts, and that's what we're going to be covering today. So what I would like you to see here, this is basically how the national portion of the exam is broken down, and the percentage of the exam dealing with each subject area. And as you can see, contracts is a very important section of the exam. So that's why we wanted to cover that for you today, and where you should be focusing your energy. CE Shop offers a series of exam preparations via webinar to help you be prepared. And this session, as I said, we will deal strictly with contracts and contract law. So to get to that subject area, as I said, it's 17% of the PSI exam. For one, I know it's also 17% of the Pearson VUE exam. It deals with the general knowledge of contract law, which are the requirements for validity, factors affecting enforceability of contracts, avoid voidable, unenforceable contracts, rights and obligations of parties to a contract, executory and executed contracts, notice, delivery, and acceptance of contracts, breach of contract and remedies for a breach, termination or rescission and cancellation of contracts, electronic signatures and paperless transactions, bilateral versus a unilateral contract, bilateral versus unilateral option agreements, and contract clauses, including amendments and addenda, offers, purchase agreements, which includes general requirements when an offer becomes binding, continuing contingencies, times of the essence, counteroffers, and multiple offers. So we're going to be breaking this down today in these various slides for you. So let's get to the first section. So contracts in real estate. There's many different kinds of contracts in real estate. We've put here the most popular and the ones that are used the most. You have purchase and sales agreements, which are between the buyer and seller. You have lease agreements between the lessor and the lessee, basically the landlord and tenant. Property management agreements between a property owner and a property manager. Buyer representation agreements, which is between a buyer and a broker. A listing agreement, which is between a seller and a broker. You have options contracts, which are between an optionor and an optionee. Contracts for deed between a vendor and a vendee. You have a ground lease. Most states don't have ground leases, but there are a few that still have ground leases. I am from Maryland, and Maryland does still have ground leases in Baltimore City. So we do cover that because it is on some parts of the exam, but most states don't have those. Independent contractor agreements is another type of a contract in real estate, and that's between the broker and the licensee affiliated with that broker as to their arrangement of being a agent with that particular broker. So let's talk about, let's talk about the exam first. Sometimes the exam, it looks like that it's designed to trick you. Generally, the question, the goal of the writer is not to trick you, but rather to test your knowledge. And a clear understanding of certain vocabulary words is very important and one step in the right direction so that you understand the questions when they're presented to you. So we're going to talk about valid, void, and voidable contracts today. So there's three similar terms, as I said, and if you use the wrong term, it may lead you to the wrong answer. So as I said, you want to make sure that you are comfortable with the terminology. So let's go to the first area, which is a valid contract. Okay, and for a valid contract, you have essential elements. You have offer and acceptance. You have consideration, legality of object. You have legally competent parties and reality of consent, which involves fraud, duress, or undue influence. One of the things I want to mention to you is that this class is about general contract law. So make sure you're not thinking about contracts for the transfer of an interest in real estate or other contracts which may have other needs, such as being subject to the statute of frauds, when we talk about all of this today. So let's go to the first area here. We have offer and acceptance, legal consideration, and legal objective, okay? But before I jump to that, let me go back and talk about offer and acceptance on valid contracts. Offer and acceptance, which is also known as a meeting of the minds, is where all parties to the agreement have exactly the same understanding of what the contract terms are. If there's no real meeting of the minds, then there is no contract and it's void. Then you have consideration. A contract must include consideration on the part of every party or company involved that enters into the contract. So an example, if a wealthy relative makes a promise to give you $500,000, which we all wish we had a relative that would do that, with no strings attached, there's no exchange of promises. If he or she decides not to give you the money, you can't force the issue because the promise was only one-sided. You have not done or promised to do anything in exchange for that money. So in a real estate contract, the buyer promises to give the seller money and the seller promises to give the buyer a deed. There is an exchange of promises. Consideration and earnest money deposit are not the same thing. You can have consideration without money. So the next area we'll talk about is legality of object. It's broadly defined as within the bounds of the law. So if the object of a contract is illegal by statute or common law, the contract will be void and unenforceable in the courts. Please note that if a contract is void, and that means it's as if it doesn't exist, it can also not be enforced against any of the parties. So an example of that would be if a hitman is contracted to do somebody in, and the party who hired him refused to pay the hitman, even though he did his job, the hitman can't go to court to have the terms of the contract enforced. Okay, so that's because there was no legality to the contract. And then you have to have legally competent parties. Parties who enter into a contractual agreement must be legally competent to do so. So generally speaking, the two situations that may be addressed on the test questions are contracts entered into by people who are not yet of the age of majority, and those who lack the mental capacity to enter into a contract. In most states, mental capacity is determined by whether the party understood the meaning and effect of the words comprising the contract or transaction. Because real estate licensees are not mental health providers, if the exam question wants you to answer based on a lack of mental capacity other than that of a minor, the question will simply say that the lack of mental capacity exists. These contracts are voidable by the party or the guardian of the party lacking the capacity to enter into the contract. And typically minors must void a contract before they reach the age of majority. Otherwise, the contract becomes valid. And then the last area you have is reality of consent. Contracts made under conditions of undue influence, such as duress or fraud, are said to lack reality of consent. You can hardly give real consent if I've purposely concealed facts from you in order to gain your consent. That would be considered fraud. Held a gun to your head, that would definitely be considered duress. Or have other power over you that I am abusing, such as a parental-child relationship, that would be undue influence. So contracts lacking reality of consent are voidable by the innocent party and enforceable against the other party. Okay? So let's move on to void contracts. Void contracts lack offer and acceptance, legal consideration, and legal objective. So under offer and acceptance, there can be no meeting of the minds if the terms are too vague to understand or if the parties never really agreed on all of the terms. So a forged contract is void as there's no meeting of the minds between the real parties to the contract. A mentally incompetent person is not legally capable of entering into a contract, making a contract void. And then you have legal consideration. There is no contract, it's void if there's no consideration. In a purchase agreement, the buyer's promise to pay for the real estate and the seller's promise to convey the title with the deed, consideration is required from all parties to a contract. And then you have legal objectives. If an employee signs an employment contract and is then asked by their employer to perform an illegal job, such as smuggling prohibited goods across a border, the agreement is void. There is no contract because the objective is against the law. Okay, for that. Right. And then let's move into voidable contracts. Voidable contracts lacks all the parties being of the age of majority, reality of consent, or a mistake of fact. So as far as age of majority, a minor may void the contract either by filing a lawsuit, asking the court to void the contract, or refusing to honor the contract and using his or her minority status if the minor is sued. If the minor doesn't choose to have the contract voided, it is enforceable against the other party. So in other words, the other party cannot use their minority status as a reason to cancel the contract. Then you have reality of consent, which means the parties freely, and I stress freely, enter into the contract. Contracts can't be enforced against a person who was forced or coerced into entering into the contract. They are voidable by the aggrieved party, and generally it's the result of duress or undue influence. So let's define duress. Duress is defined as involving using intentional use of force or threat of force in order to induce the contract. It can be either physical or mental coercion. Undue influence involves using your position of trust or authority to get the other party to agree to contract terms. This involves using the relationship to unfairly persuade another to agree. And then you have mistake of fact, and that may be voidable if the court finds it material to the transaction. So an example of that is if a seller owns two vacant parcels adjacent to each other, one of which is suitable to build a house on and the other which is not, and the seller contracts with the buyer to sell the buildable lot. The listing agent, however, confuses the legal descriptions and the contract is ratified with the legal description of the unbuildable lot. This is a case in which a material mistake of fact is likely to cause a court to void the contract or allow the purchaser to use the mistake as a valid defense in the event the seller attempts to enforce the contract. But you need to keep in mind that in a voidable contract situation, generally it is only the minor or the aggrieved party who is able to have the court enforce. It might be said that the contract is enforceable against the adult by the minor or against the party using undue influence or duress by the aggrieved party. All right, let's move on here to unenforceable contracts. So unenforceable contracts, two reasons: not in writing and it's void. So even though there may be a valid agreement for the sale of real estate between the parties, the statute of frauds requires that contracts for the transfer of an interest in real estate, including those for leases of 1 year and longer, be in writing in order for a court to be able to enforce the contract terms. Therefore, most contracts must be in writing as well as being valid to be enforced. Okay, for that. All right, so let's move on. I'm going to ask you a question here. Which of the following is a court least likely to enforce? And we're going to put that poll question up for you to answer. Okay, we have about 65% of you that have answered this question. So we're going to stop the poll at this point. And it looks like we have 67% that said a handshake agreement for a 2-year agricultural lease against either party. And we're going to go over here to the answer. And the answer is C. So you obviously are studying your course very well and understanding it. So yes, the answer is a handshake agreement for a 2-year agricultural lease against either party, because it's not in writing, okay, for that. All right, let's go here to the next one. A buyer offers to purchase real estate owned by Francis and Robert Horton. Due to a recent stroke, Francis can't read, understand, or agree to the offer. Robert knows that Francis wants to accept the offer. He signs her name. The contract is what? And if you can answer this poll question for me. Okay, so it looks like I have about 76% of you that have answered it. So I'm going to stop the poll at this point. And it looks like we have the majority saying that it's void. And at this point, we're going to go. And the answer is A, void. It cannot be signed for another. The contract cannot be signed for another. You do not have a meeting of the mind of all the parties. Even though the man might think he knows what his wife wants, he cannot sign for her on this, and the contract is void. Okay, so now we're going to talk a little bit more about some vocabulary words. As we said, it's important that you understand the difference between some of these words. And right now we're going to talk about expressed and executory. Executory and executed. Okay, so executory is basically where something has not been fully performed. So if you have a contract that has not gone to settlement yet, it's still in the executory stage because it hasn't been completed. And then if it goes to settlement and the deed is transferred to the buyer and the seller receives their money and the closing has been completed, at that point, the promises have all been completed and it has been executed. And then your next two words are expressed and implied. So expressed is defined as something that's spoken or written. Obviously, if it's written, you know exactly what they mean when they write it to you. Implied is by action. So if you see me at my house and you see when I open the door, my dog comes running up to me with the tail wagging and jumps in my arms, it's implied that my dog likes me. But there's no written definition to that or no written explanation of that. It's just implied. But with express, as I said, it's definitely spoken where somebody says to you, I love you, or you have something that's written down, I love you. That's obviously expressed for that. And then you have unilateral and bilateral. So unilateral obviously is one party, one person, una, promises to a second party. Only one party is bound. It's a promise exchange for performance. In bilateral, you have two parties that make promises. A promise for a promise. So that's the difference between unilateral and bilateral. That one's probably the easiest of the slides that we're going to have here because you have uni for one and bi for two for that. Okay, and then you have optionors and an optionee. So you own real estate and you're the seller, and you're going to grant the option to purchase to an optionee. So at that point, the seller is the optionor and the purchaser would be an optionee. You must sell if the optionee exercises their option within the option period. You may not sell to anyone else during that option period. Now the optionee basically pays option money for the right to purchase the property. So they become basically the buyer. And it has to be done within a contracted period of time that's in the option agreement. And they are not compelled to purchase it at all. They've either agreed to pay some money if they don't purchase it. But for the most part, if they decide not to, then they give up that money. And that's why it's called an option agreement, because they are not bound to purchase it. Okay, so here's another question for you, poll question, see if you know the answers to this. Hans and his landlord sign a 1-year lease, residential lease, and Hans pays his deposit on April 15th. He moves in on May 1st and pays the first month's rent on April 25th. He moves out on May 1st of the next year. What's the lease status on April 25th? And if you can answer that one for me. And try to answer it, even if you're not sure. Put in what you think it is, because it'll tell you whether you were, wrong in your thoughts, and you might surprise yourself and be right. Okay, so it looks like we have 31 or 60% that decided that the answer was expressed and executed. And we're going to go to the answer here. And the answer is expressed and executory. And the reason why is the express part is all written in the lease and signed by all the parties. The executory is as of April 25th. The lease is ongoing until the following May. So it is not executed until the lease is over. So that's why it's still in the executory stage for that. Okay. And then the next question is, Devin paid $10,000 for a 5-year option to buy farmland. What happens in the event that Devin decides not to go through with the purchase? If you can answer that poll question. Okay. So it looks like we have about 49% that are at C. And we'll go to the answer here on the next slide. Get my pointer here. And the answer is C. The seller may return the $10,000, but there's no breach of contract because it's an option agreement. And he gave the $10,000 for the right not to go through with the purchase. So that's why that's correct for that. All right, so let's jump to another subject area. We're going to talk about offers, counter offers, and contracts. You have properties listed and advertised. That's at that point, the property's just listed. It's what it is. Then you have an interested buyer who submits a written offer. And at that point, the purchaser may withdraw the offer up until the time it is accepted by the seller. If the seller rejects the purchaser's offer and sends a counter offer to the purchaser, the seller has become the offeror and purchaser is the offeree at that point. And then the seller may withdraw their counter offer up until the time it's accepted. So let's say the purchaser rejects the seller's counter offer and sends another counter offer to the seller. The purchaser once again becomes the offerer and the seller the offeree. The purchaser may withdraw the counter offer until the seller accepts it. And then the seller, let's say, accepts the offer and notifies the buyer, which is basically giving notice of acceptance to the purchaser, which creates a contract between the parties. So you can go back and forth between being the offerer and the offeree in a contract, depending upon what stage of the negotiations you're in. You start out as the offerer, and then you might be the offeree if you're countered by the seller for that. Okay, so here's another question for you. Which of the following does not terminate an offer? I really like this question because it has a lot of things in it that you'll come across if you're selling real estate. So it's good to know what the correct answer is for this particular situation. Okay, so I think we have about 70%, and the answer to what does not terminate an offer is the highest answer was 53% said counteroffer. And we're going to go to the next slide and I'll tell you what the answer is. And the answer is C, which 22% of you said. Here's the thing, a counteroffer does terminate an offer because you didn't accept the offer that was given to you. you've countered with another offer. So the failure of an offeree to respond within 48 hours, there is no law that says that an offer has to be responded to within 48 hours. None that I know of in any of the states in the United States that I know of. So you could ask for the seller to respond within 48 hours, but unless you would put that in writing in the offer, it would not terminate the offer. Okay. All right. So let's go to the next one. At what point in negotiation for the purchase of real estate is the offer effective? Okay, so it looks like we have 65 or 70% of you, and your answers are the 52% of you said when signed by the offeree and communicated to the offerer. And the answer to this one is D. Okay, when signed by the offeree and communicated to the offerer. So you have a good understanding of that one. If it's not communicated back by the offeree to the offerer, then there is no contract at that point. It's not effective yet. Okay, let's go to the next slide. And the next poll, which is, which of the following is not a method that buyers are likely to use in a multiple offer market? One of the things I'll bring to your attention while we're doing this is, you know, we have had questions in here that have, they're basically asking you what not would happen, or what, they're using the word not in the questions. So when you read your questions on your exam, you need to be careful that you're reading them thoroughly and not reading it to say what is going to happen. They're basically saying what's not going to happen in a situation. Okay, so we have, at this point, we have almost 70% again. So we're going to look at the results, and we have 38% of you that said that the buyers were most likely not to use, which is leave out contingencies for the buyer's protection. And we'll go to the answer. And the answer is D. And again, this is where you have to look at the questions when you're looking at the exam. You don't want to offer what to put in there that you'll offer whatever the appraisal is, for one. First off, the appraisal could come in at a higher price than what the property's being listed for. But secondly, you know, you're leaving yourself wide open for that. You also don't want to not put in your contingencies for the buyer's protection. Sometimes they do leave them out, but it's not a good idea to leave them out for that. So the chances are here that they're not going to use the offer to pay whatever the appraisal is, because it's an unknown for that. Okay, so let's move on to the next one. So now we're going to talk about the electronic signatures. So you have the Uniform Electronic Transaction Act, okay? And it applies when parties have agreed to electronic transaction. The UETA only, and that's how it's referred to as the UETA, only applies when the parties have agreed to conduct the transaction electronically. And an electronic signature can be an electronic sound or a symbol or a process that is both, but it has to be attached to and associated with the contract, and it has to be executed with the intent to sign. So the UETA has been adopted by 47 states, the District of Columbia, Puerto Rico, and the Virgin Islands. So it's very well accepted. The 3 states that have not adopted the UETA are New York, Illinois, and Washington State. But they have adopted similar laws making electronic signatures legally enforceable. Neither a signature nor a contract may be denied legal effect merely because they are done in an electronic format. So accordingly, contracts which would otherwise be enforceable if an original was executed and delivered by paper and blue ink, they will generally be enforceable if executed electronically. So e-sign was signed back in law in June 30th of 2000 and took effect in October 1 of 2000. And e-sign applies to federal law and preempts any inconsistent state law, with the proviso that if a state adopts the UETA without amendment, e-sign will not preempt the enactment of UETA. Okay, that one. All right, so let's move on to when contracts can be terminated. You have several reasons why contracts can be terminated. You can have mutual agreement. You can have performance of the contract, impossibility of performance, mistake, fraud, or misrepresentation, or breach. So let's break those down a little bit. So to terminate a contract means to end the contract. The contract can end, as I said, if all the parties mutually agree to terminate the contract, or once the obligation of the contract has been met by all the parties, the contract then ends. Sometimes a contract becomes impossible to perform. So, and that happens after the contract was made. So an example of that could be a natural disaster might make performance of a contract impossible by preventing a party from fulfilling their obligation. The house burns to the ground, or you have a tornado and the house blows away. You cannot perform in that contract, so therefore the contract could be terminated. If a contract is formed under conditions involving mistake or misrepresentation or fraud, the contract may be terminated since it was not formed according to sound contract principles. In the case of a misrepresentation, the contract may be voided or basically terminated by the innocent party, but not by the party who made the misrepresentation. And if the misrepresentation involved fraud, also the innocent party is the one with the right to terminate. In the case of a mutual mistake, if both parties are mutually mistaken about a material fact, then a contract can also be rescinded by either party. If the mistake is unilateral, then the right to terminate depends on a number of factors. So, for example, if one party is mistaken about a material fact under the contract, and the other party knows or suspects that it's a mistake and uses that to their advantage, then the party who was mistaken may have the right to terminate. But if the mistaken party did not do reasonable due diligence in the contract, a unilateral mistake is not sufficient reason to terminate the contract for that. And then a party to a contract may also rescind a contract based on a failure of the other party to live up to their agreement. In other words, a breach. A refusal or failure of a party to perform his part of the contract or a clear intention to violate it gives the other party the right to rescind the contract. Okay, so let's jump to a couple more vocabulary words here. We're talking about breach. And breach is a contract may be terminated for a breach. It also can be terminated if contingencies are not met. And examples of the contingencies would be you have a loan contingency. The buyer is supposed to apply for a loan within a certain period of time, and they don't do that, and the contract is contingent upon them getting a loan, well, if they don't apply for the loan, obviously they're not going to meet that contingency, and the contract it could be considered, void because they are not, or basically they're in breach of the contract because they have not filed for their loan application. It's also provisions for an unforeseen event or circumstances. And also, most of the time, the contingency clauses will stipulate what will happen if the contingency is not met. So you usually will have a section in there that says, if you don't apply for the loan, the seller can declare the contract null and void for that, okay? So what are some of the remedies for breach? You have rescission. When one of the parties to the contract does not fulfill their obligation, then the other party can rescind the contract and refuse the performance of their obligation. You can sue for damages. You can have liquidated damages. Sometimes liquidated damages are named already in the purchase agreement and are named as with a definite amount in mind. And they usually, when you have liquidated damages clauses in a contract, you're not likely to require a court case to collect those liquidated damages unless there's a disagreement between the parties about why the contract was breached, which happens a lot. And then you have, many purchase agreements prevent a party from both accepting liquidated damages and suing in the courts for damages, but not all of them do that. And then you can sue for specific performance. However, when you sue for specific performance, you're asking the courts to say that the seller must sell you that house. The seller at that point cannot sell that property when it's under a court case to anybody else, and you have to wait until the court decides whether they have to sell it to you or not. So it's a very long, drawn-out process to do specific performance. You don't see that happening as often as it did years ago for that. Okay. All right, so let's go to another poll question here. And that question is, rescission, receipt for specific performance, liquidated damages, and acceptance of partial performance are, and then you can answer the questions there for that. Okay, so it looks like we've got about 65% of you that have responded to that one. And we see that 61% of you have answered C. And just so that you know, you were correct with that. They are options offered to the innocent party has available to them to try to remedy the breach. Okay. Some of those clauses you might see in a contract, but for the most part, you're not going to see issues about specific performance in a contract. So number C, again, would be the best answer out of all these answers for that. Okay. All right, let's move on to the next one. The purchase contract states that Megan will pay $50 daily rent to take possession of Steve's house before closing. The contract notes that time is of the essence. If Steve can't give Megan possession on time, which of these is not an option for Megan? And you all can answer that one. And since this is sort of a review class, and I apologize, my phone just went off and I can't find it. You'll note again, this is one of those questions that says, which of these is not an option So you want to be careful and look out for those type questions when you're taking the exam. All right, let's move on. We have about 56% and 54% of you said that the answer is D, and you are correct that D is the answer. You can have Steve charged with criminal trespass. He still owns the property. He was just giving you the ability to rent it. So therefore you can't have him charged with criminal trespass for that. Okay. All right, let's go on to the next one. Which of these statements about the Uniform Electronic Transaction Act is correct? And if you could answer that question for me. Okay, so we're about 65, 70% on this. And we have 57% that said A. And the answer to that question is not A, it's B. And again, you look at the question, which of these statements is correct? All right, it does not require that you use electronic signatures. You don't have to use them if you choose not to. It has not been adopted by all the states. And real estate brokers, although most of them have this platform available to them for their clients, they're not required by law or by any situation where they're required to have it. So the best answer here is it permits sounds to be used, because that is correct. It permits sounds to be used as a signature if a party intends for that sound to be their signature. Okay, let's move on. What is the impact of a statement of liquidated damages in a contract? And if you could answer that one for me. And once again, you want to look at these and look at what is the best answer. Okay, so we're about 65%. So at this point, we have that 62% of you said C, that the amount of liquidated damages has been agreed to by the parties. And the answer is C, and that is the best answer. Lawsuits are not precluded. You can have a lawsuit. There are other remedies available to the parties, but the statement of liquidated damages is not involved with that. And then if there's a lawsuit, the court is precluded from awarding a different amount, and that's not true. They can award a different amount. They don't usually, but they can. So the best answer here is the amount of liquidated damages has been agreed to by the parties for that. All right, let's move on. So we have Sally offers to buy Ricardo's real property. While Ricardo is considering the offer, Sally's agent notifies Ricardo's agent that Sally's withdrawing her offer. What happens if Ricardo signs the offer before his agent notifies him of Sally's withdrawal? I'm going to find the answer for that one here. All right, so we're almost up to 65%, so we'll move on with this one. And we had 32% that said the contract was accepted before withdrawal and is binding. We had, that was the largest answer that we had for this one. And just so you know, the answer is, oh, sorry, I jumped a slide, is A, there is no contract. And the reason there is no contract is the notice was given to Ricardo's agent before the signed document that Ricardo signed was delivered back to Sally's agent, okay? So there is no contract. And again, you wouldn't have an earnest money deposit because there was no accepted contract at that point and the money had not been deposited. So you wouldn't have any deposit to deal with for that. And if there's no contract, you can't terminate one for that. So the answer is A, there is no contract because it was not delivered back. The notice was given to his agent before it was delivered back to Sally. All right. All right, let's move on to the next. All right, so let's talk about some common clauses that are in contracts. You have assignment clauses prohibiting assignment of the contract without permission of the seller or buyer. Most purchase agreements and leases are assignable unless assignment is prohibited. I do know that most have a clause prohibiting the assignment of a contract, but not all states have that and not all contracts have that. So there are sometimes assignment clauses. You have escalation clauses, and escalation clauses deal with a possible multiple offer situation. And you really want the house and you know that there's 3 or 4 contracts. So you might put in an escalation clause that says, I will pay you $500 more than whatever the highest price is that you're being offered. That could be the escalation clause. Obviously, you're going to want proof that they got that contract for the amount that you're going to pay $500 more than. But you put that, and most times people in an escalation clause will say, I'll pay $500 more up to a maximum amount of a certain dollar amount. Okay. And then you have contingencies, and there's a ton of contingencies that you can have in a contract. And this is usually where you see contracts starting to fall apart. You have inspection contingencies where you have home inspections done. You have radon inspections. You have well inspections. All types of inspections fall under that category. You have a financing contingency, which I talked about earlier, where you didn't meet that contingency. You didn't apply for your financing to get the loan to purchase the property. Then a lot of times you'll have a contingency says that your purchase is contingent upon the property appraising for the price that you're offering for the house. You want to make sure that it's worth what you're paying for that. And then sometimes you have a contingency for the sale of your current home. You're moving up. You're moving from your first home to your second home. So you need to sell your first home and use the equity that you have in that to purchase your second home. So you'll have a contingency for the sale of your home in order to purchase the new home. In that light, you can then, the seller would have possibly a kick-out clause that they would come back to you with that says, I'll accept your contingency for the sale of your property. However, if I get another offer that doesn't have any contingencies in it that deal with the selling of their house, I have the right to either kick you out of your contract, or you can show me that you can purchase the property in the same manner as this new offer that I've gotten. Okay, so there are the different types for buyers and sellers: the sale of the property for the buyer, and the kick-out clause from the seller for that. So pretty much we've covered all of the contract issues today, and I know you're going to get the slides so that you can review them later, but we wanted to talk to you a little bit about the exam itself. So PSI and Pearson VUE are the 2 exam vendors that offer the national portion of the real estate exam. They are both Orelo certified exams. And a lot of times during those exams, they put in what they call experimental questions. Each state or each exam vendor has questions that they bring in that are new questions, and they test them out. And they usually put 5 to 10 experimental questions in the exam. But what you need to know, and I can attest to this personally because I've been involved in doing this, that those questions are ungraded and they do not go towards your exam. The timer stops as far as the time you're allotted for your exam. The timer stops when you're answering those questions. So it's not cutting you off from having the right amount of time for your exam, but they will be in there. We just like to let you know that they will be in there. And then also you need to look at your candidate guide for each state. Each state has different rules and regulations. So it will tell you what the total questions are that are going to be on the exam. It'll tell you what that state's particular passing score is. Some are 70, some are 75%. And also, when you're doing the exam, you want to make sure that if you have a question that you're not sure of, just mark it and go back. You can change your response, provided your time hasn't run out. So you don't want to mark too many of them. But if you're really hanging on with one particular question, just mark it and come back to it. My personal opinion, as I said, is go with your gut, because usually it's right the first time. And if you study for this, you should be able to do this. And again, watch out for the fact that a lot of the questions have a negative to them, not a positive. And you want to make sure that you're following what the question is and reading the question thoroughly. So here's some preparation tips for you. Find your test center in advance. I believe that all the states are reopened. Amy, maybe you can answer that.
As far as which states are reopened?
Are most states reopened now for taking the exam?
I do not know. Does anyone else from the CE shop know the answer to that?
Hi, it's Jill. If I can just jump in for a moment.
Sure.
All you need to do is, thank you, go to the website. So it's pearsonview.com or psi.com, psiexams.com, or you still may have AMP. It's owned by PSI, and that's goamp.com. And you can find out which test centers may still be backed up, but most of them, I believe, are open now.
Okay, thanks, Jill. Also, you want to make sure you get a good night's sleep before you take the test. And I was talking about going to your test center early or in advance so you know where it is. That's a good idea, and you can judge the traffic and things like that. But you also want to arrive early so that you can get yourself settled. You know, they ask for your ID. You need to have two forms of ID, which is one is a government issued ID with a photo and a signature, and then another one with a signature and printed name on it. You cannot have your cell phones are prohibited, or any communication devices like Apple watches, things like that that have access to the internet. Make sure you use the restrooms before you start your test. And then also you can have non-programmable calculators, only numeric keyboards if permitted. If not, you want to make sure that they are, I'm not sure that all the centers are providing calculators, so you want to check on that, make sure. What happens if you don't have a non-programmable calculator? So look that up ahead of time. And as I said, don't allow a challenging question to upset you. And don't spend too much time on one question, which I said earlier. It's important that you can mark them and go back to them. But try to answer all the questions. Try not to leave any of them blank. You have to have probably a 25%. If there's 4 answers, you have a 25% chance of being right if you answer the question as opposed to not answering it at all. Okay, so at this point, I'm going to turn it back over to Amy, and she's going to field the questions.
Yes, thank you so much, Kathy. I'm hoping that all of our participants today found it useful answering or trying to answer all of those questions. I think that those were awesome questions, and it should give you a good sense for what you might get in your exam. We are going to take some time for questions now. Just a reminder, please be sure to type those into the chat box in your control panel. And it looks like we have a few of them. So let me see. All right, Megan asks, if a seller signs but amends an offer, say by changing a closing date, rather than submitting a counteroffer, can the purchaser then rescind the contract if the amendment is not agreeable? Or does the amendment change the contract enough to allow the buyer to rescind the contract?
Okay, so the answer to that is by the seller changing the closing date, it has automatically become a counteroffer. Okay, so that is a counteroffer. If he sent it back with a new closing date in it, it would have to be initialed by the purchaser because that is considered a counteroffer. Does that answer your question, Megan?
Yeah, that's great. Megan, if you have another question to follow up, go ahead and put that in the Q&A. Let's see, Amanda asks, do you know which questions are the experimental ones on the test? And does the test let you know?
No, they don't tell you which ones are. Okay, and they're not going to be questions that deal with something that you don't know. Okay, they're gonna be involved with something that you've learned. So what they like to do is just create new questions sometimes and change them up because they start to get stale after a while. So they just start changing them up a little bit. So no, you're not going to have to worry about. You're not going to know which ones are which.
Okay, and Leslie wants to know what formulas show up on the test.
I'm not sure. Probably math formulas dealing with percentages for mortgages and what your payments are going to be for you have a loan for $300,000 for 30 years. It's at 5% interest. And they're going to ask you to add all those different things up and come up with what the principal interest payment's going to be or something on those lines.
Okay.
May I jump in for a minute, Kathy?
Absolutely.
Jill?
Yeah, go ahead, Jill.
May I jump in for just a minute for Leslie? Thank you. So Leslie, if you go to our website and look at the recorded webinars we have one that is specifically on math calculations for real estate. And most of the formulas that you need to know will be in that webinar.
And to answer your second question, Leslie, is can I bring a cheat sheet? The answer is no.
That'd be nice, wouldn't it? That'd be really nice. Okay, here's another one. If I rent a house to a minor, but the minor turns 18 while living there, can that minor, who's now 18, still void the contract?
No, I think we answered that in the questions that said if a minor wants to void the contract, they have to do it before they reach the age of majority.
Okay, and here's another one. I'm still not quite clear about unilateral option contracts. If the optionee pays money to the optioner, why isn't that bilateral?
Well, I'm not sure where you got that it was a unilateral agreement.
Okay, so in other words, paying money means that it is bilateral, correct?
No, because well, let me see if I can answer this. On an option agreement, it's not a contract. Okay, it's an option. So you're paying money for an option to purchase. And if you choose not to exercise that option, you've agreed to pay a certain amount of money. Whereas a contract, you're offering to buy and the seller's agreeing to sell. So that would be considered a contract because it's both of them have agreed to a promise.
Okay. And
one thing I might add to that. Yeah, one thing I want to add to that. An option is I think whoever asked that, an option is a unilateral contract. But if you remember what Kathy told you, that unilateral means a promise, and the optionor promises to sell the property if the optionee buys it. The optionee, on the other hand, has given money, and so they have already performed. So it's a promise for performance. The optionee doesn't have anything left that they're obligated to do. They've already done anything they were obligated to do. There's nothing more for them to do. Hope that makes sense.
yeah, thanks, Jill. Here's another one. What is the most important part of contracts to know for the licensing exam?
Can you say that again for me, Amy?
Sure. What is the most important part of contracts to know for the licensing exam? Sum it all up for us.
Well, I think it's all important. It really is. It's all important. And I think knowing your vocabulary, understanding option or option E, executory, executed, the vocabulary is essential, because if they put the wrong, or if they put a word in there to, basically that it's not the right word, and you read it and you don't understand the definitions, then you're going to think the answer, what they wrote, is correct, and it's not. So I think knowing your vocabulary on the different terms for contracts is very important.
I also like how you pointed out that many of those questions will have not in them, which of this option is not correct, because
Exactly.
those do show up regularly on the exam, and I know that a lot of students struggle with those. Okay,
Right.
let's see. We've got a couple more. I don't understand how a buyer competing against other offers is most likely to not offer the appraisal contingency as opposed to the buyer's protection contingency, like the inspection. This, Luco says, this was the question most of the group got wrong. Can you re-explain that?
Sure. Well, first off, the answer, I think, was that the buyer agreed to pay whatever the house appraised for.
Yes.
Not a contingency that it was worth what they were paying. The answer was that they would pay whatever the appraised value was. So that might answer your question right there. You can have a appraisal contingency that says, I'm paying you $500,000, but if the house only appraises for $475,000, then we're going to have to renegotiate.
Good. Yes, the question was not about an appraisal contingency, like you said, but it was a buyer saying, I'll pay what the appraiser says, which is right. Not a good strategy in a multi-offer situation.
Dollar amount. It's an open-ended dollar amount. Yeah.
Mm-hmm. Okay, here's another one by Demola. What kind of proof is provided to know the buyer has won the bid in an escalation clause?
Well, normally what happens is if you win the bid with an escalation clause, the listing agent provides you with blockouts of names and things like that. They'll provide you with a copy of the contract, not necessarily the full contract, but at least the essential parts that show that they got the contract with that amount that your escalation clause is based on. And there is some ethical requirements here that agents have to be honest and fair with all parties. So they are required to make sure that they do have exactly what they say they have, that they're not just making it up.
Okay, good. Thank you. We've got one more. And this is, I think, a good one from Susan. Are the questions that you presented, Kathy, are those of comparable difficulty as those on the licensing exam?
I can't say I don't think they're any worse. I can tell you that most exams are built to be for the minimally competent person. And at least for Maryland, I know it's to an 8th grade level, if that helps.
Okay. Yeah, I found your questions challenging too, but I would just say to those who are here that it's great to tackle challenging questions and think them through, because if you can, you'll be in much better shape for the exam.
Exactly.
So, all right, it looks like we've covered all of our questions. Kathy, is there anything else you wanted to cover before we wrap up?
No, I think I'm good. I just wish you all luck with your exams. And again, don't overthink it. Just go with your gut. Study hard, because you really should study. A lot of people think if they don't, just because they think they know it, they don't have to study. You do need to study for these, and the CE Shop gives you so many great tools to study for this exam. So make sure that that you do study for it. And I just wish you all luck on the exam.
Great. Thank you, everyone. We appreciate that you took the time out of your schedule to join us. I'd also like to thank Kathy for joining us today. Your knowledge, expertise, and willingness to share it with our student community is greatly appreciated. So look for an email from us with a link to the recorded presentation, and be sure to register for our upcoming webinars. And thanks again for joining us today. We'll see you next time.